Hello viewers and students, this is Dr.K Neharkar and I welcome you in my YouTube channel at lecture series on labor laws first. Friends, in this lecture we are going to discuss employer's liability to pay compensation. It means when employer is liable to pay compensation and when employer is exempted from payment of compensation. These provisions are provided under the Workmen's Compensation Act 1923, now which is known as the Employees Compensation Act 1923. Friends, firstly we are going to discuss the concept of accidents, etc., and the reasons or the object for which the Workmen's Compensation Act was enacted. As you know, in industry there are many processes of manufacturing, etc. Many activities are carried out. There are many operations and in which the accidents may happen. So, and such accidents may result into casualties, and the workmen are the common victims of such accidents. The workmen may lose their life, they may lose their limbs, it may affect their earning also. Therefore, when any accident happens, it results into injuries, it results into the accident. But in case of fatal accidents where the workman lose his life, in such circumstances the dependents has to face many problems like begging, etc. Therefore it needs the compensation to workmen or their dependents, and that is the reason why the Workmen Compensation Act 1923 is enacted. We must say what is the object of act. This act is the first social security and social welfare legislation, because the act is enacted to provide welfare to those workmen who get injured or who meet with death in accident. So this act is enacted with following objects. The first object is to provide compensation to workmen for accident, injuries in the course of employment. Second object is to protect interest of dependents in case of fatal accident. Fatal accidents means the accident where the workman meets with death. Then to reduce hardship to workmen, to fix the employer's liability for payment of compensation in case of accident as well as in case of occupational diseases, to create confidence among the workmen. So these are some important objects for which the act is enacted, as to prevent fraudulent litigation. This is also another important object of the act. So now we must see when the employer is liable to pay compensation under the act. Section 3 of the act specifically deals with the circumstances and conditions when employer must pay compensation to his workmen. So these conditions we must see. Employer is liable to pay compensation in the following conditions and circumstances, and these conditions are as under. The first condition is the personal injury must have been caused to workman, that may be resulted out of accident or occupational disease, whatever the nature is, but there must be the personal injury caused to workman. Then such injury must have been caused by accident. This is second circumstances, that injury must be the result of accident. Then third condition is it may be resulted due to occupational disease also, because we can easily witness, we can easily find the accidents happening of accident, but occupational diseases we cannot see it easily, but it also results into harm to health, etc. If the accident injury results into the death of workman, there must be the causal connection between injury and cause of death. So this is the fourth condition, it must be satisfied. There may be certain circumstances where accident happens and that person receives the injury, and that person may not meet with death immediately, but after the period of few days that person may die. So there is no direct connection between the happening of accident and death, but if such death of that workman is a result of injury, then it is called as a causal connection between injury and death. Then next condition is the accident must have resulted or arisen or in the course of employment. This is very important. And see, because the employer is liable to pay compensation only when that accident results in the course of employment and out of the employment. So it means that accident must have happened within the industries at the time of working and at the place where that workman is employed and while doing that work which is allotted to him. So this scope of this condition is very wide. So when this condition is satisfied, again the employee is liable to pay compensation. You must remember that that accident must happen within industry, that accident must happen within that time period, the accident must happen during the work which is allotted to that employee. So these are very points. Then next is notional extension of office premises. So friends, this is very important principle, notional extension of office premises. This is very important principle, as the previous condition provides that accident must happen out of the employment and in the course of employment and within the industry. It means whether any accident which has happened outside the industry, whether that accident can be called as in the course of employment, and whether that workman is entitled to get the compensation. These problems or these questions are solved by this principle, notional extension of. Therefore we must see what is notional extension of office premises. The premises, according to this principle, the premises of office do not begin with employer. The premises of office do not begin with when employee enter into the gate of office and do not end when he leave the gate in evening. But the notional extension of office premises includes both ends. When workman starts his journey from his home towards his office and when he leaves his office for his home. So the premises of industry are extended beyond that gate to include all those accidents which happened on the way when that workman was on the way to industry or from that industry to his home. But this principle must be applied with very caution, because that accident must happen within a reasonable time, on a reasonable way, etc. All these are the some important points that must be considered. Regarding that, there is case law, that is in TNCS Corporation versus Puma Lai, where the death of workman was caused in communal right when that person was on the way to industry. In this case, the notional principle of notional extension was applied and the dependents were declared as entitled to get the compensation. Secondly, in Jayantilal Dhanraj and Sons Company Limited, Employee State Insurance Corporation, the unskilled workman died while removing the belt of crushing machine. In this case also, the notional extension of office premises was applied and the workman's dependents were declared as entitled to get the compensation. So Last condition is that the injury must have been resulted in death of workman or his total or partial disablement for more than 3 days. So friends, these are the conditions where the employer is liable to pay compensation. Lastly, it is responsibility of worker, it is responsibility of claimant to prove that he is entitled to get the compensation. Now we must see what are those circumstances when employee is not liable to pay compensation, because these are the conditions where employer is exempted from paying compensation. The first condition is that if accident do not result into total or partial disablement for period exceeding 3 days, it means where such accident results into disablement for a period of less than 3 days, the employee is entitled to get the full wages for that period, and after that he can join the work. Then second condition is that the workman willfully disobeyed the instruction or safety measures, because the accident is caused due to the disobedience or not following the safety instruction. Then third condition is if that workman is in a drunkenness or is under the influence of any drugs, etc. In such condition also the employer is not liable to pay compensation. When workman willfully removes safety guards, this is also one reason or the ground where the employer is not liable to pay compensation. But this disobedience, removal of safety guards, not following safety measures are not applicable in case of death cases. Even though death is resulted due to disobedience of instructions, removing safeguards, it is liability of the employer to pay compensation, because the worker has to lose his life, and here it is necessary to protect the interest of dependents. Now we must see what is employer's liability in case of occupational disease. Section 3 further provides the employer's liability to pay compensation in case of occupational disease. See, that provides specifically what is occupational diseases, or it provides list of occupational diseases by schedule 3 of the act, and therefore the such diseases may be pneumoconiosis, pneumoconiosis, like these are the diseases which are related to respiratory system, like the pneumonia, etc. And such diseases may be caused to all those industries which use such a hazardous chemicals, etc. Even the industries like asbestos, etc. In such industries the disease may be caused to lungs, etc. The diseases may be relating to lungs diseases and that may result due to the inhalation of dust, etc. Then we must see what is a procedure for calculation of compensation. Section 4 of the act provides the procedure for calculation of compensation, and according to that the amount of compensation shall be different for death, permanent disablement, total disablement, permanent partial disablement, and temporary disablement. So different kinds of compensation shall be given to different disablements, different injuries. So firstly we must see how the amount of compensation shall be calculated, and the amount will be calculated in accordance with section 4 and other provisions which are read with 4th schedule of the act. So 4th schedule of the act provides a list of amount of a relevant factor. As you know, the relevant factor is nothing but it is an amount, it is indexing number which depends upon the age at the time of accident. For example, if that accident was caused where that accident was caused, and at that time the age of that workman was 16. For the age of 16, the relevant factor is 228.54. If the age is 32, the relevant factor is 203.85, and if the age is 65 or more, then in such circumstances relevant factor will be taken as 99.37. So now we see how the amount of compensation shall be calculated with the help of such relevant factors. So firstly, the compensation in case of death, where the death results due to that accident, then the amount of compensation shall be equal to 50% of monthly wages, which is multiplied by a relevant factor, or an amount of rupees 1,20,000, whichever is here. As I have already told you, that firstly we shall determine what shall be the amount of monthly wages of that workman at the time of accident. Then we must find 50% of monthly wages. For example, if the monthly wages of that workman is 3,000, the 50% of monthly wages will be 1,500, and that amount of 1,500 will be multiplied by a relevant factor. As I have already told you, that relevant factor is dependent upon the age of that workman. If the age of that workman is 65 at the time of accident, then that rupees 1,500 will be multiplied by 99, and what will be the resulting amount? That will be the amount of compensation. So that amount of compensation shall be rupees 1,20,000, or what the amount results by that multiplication. So whatever the higher amount, that will be the amount of compensation. And in the case of death, rupees 2,500 shall be immediately deposited with commissioner for funeral expenses. So this is amount of compensation in case of death. If any viewer do not understand how that to be calculated, they can write me in the comments, so I can solve the query. The second amount of compensation shall be in case of permanent total disablement. In such case, the amount of compensation shall be equal to 60% of monthly wages and multiplied by a relevant factor, or amount of 1,40,000, whichever is higher. So here the monthly wages are taken as 60% of monthly wages, and that will be multiplied by a relevant factor applicable on the basis of his age at the time of accident. So whatever the resulting amount, or rupees 1,40,000, which the amount is higher, that will be the amount of compensation. The next amount of compensation shall be compensation in case of permanent partial disablement. See, when that accident results in a permanent partial disablement, then the amount of compensation shall be determined on the basis of loss of earning capacity at the time of his employment. So we must consider what was the earning capacity of that workman before the accident happens, and now what is his earning capacity after the accident. So on that basis, the qualified medical surgeon will decide the loss of earning capacity, and on that basis the compensation shall be paid to him. Then the next is the compensation in case of temporary disablement. So when any accident results into temporary disablement, then the amount of compensation shall be in the form of half monthly payment of sum, which is equivalent to 25% of monthly wages. It means in this case, that workman will receive quarterly amount of monthly wages for every 15 days. So ultimately he will get 50% of wages for month. So then we must say what is next provision relating to compensation. The compensation to be paid when it becomes due. Section 4 of the act, 4a of the act specifically provides that the work employer shall pay amount of compensation immediately as it becomes due. He shall not prolong the payment of compensation. Then section 8 of the act deals with the payment of compensation and its distribution. So section according to section 8, the amount of compensation for death of workman shall be paid by employer by depositing it with commissioner, and the amount which is paid in other way shall not be deemed as it is paid. So this care has to be taken by the employer. He must pay the amount not directly to the dependents, but he must deposit such amount with the commissioner. Then the amount of compensation shall not be attached by any way. As you know, in the consequence of any decree by court against the person, his properties can be attached, his properties can be seized. But here the amount of compensation which is given under this act may not be seized, may not be attached, may not be charged by any operation of law, by decree of courts, etc. Nothing, or even in an insolvency case also. Then next point we must see is penalties. Section 18a of the act deals with penalties. If employer fails to maintain notice book that is given for claiming compensation, he fails to submit necessary reports of accidents, he contravenes any provisions, then he shall be punished with fine which may extend to rupees 5,000. So friends, we have discussed the provisions relating to employees' liability to pay compensation and when employer is not liable to pay compensation. We further discussed what is the procedure that must be followed in calculation of amount of compensation. So if you like this video, please share with your friends. For any queries, doubts, you can mention it in the comments, and do not forget to subscribe my channel. So thank you friends.